Good afternoon, everyone. My name is Penny Hayes. I'm the COO of the Trust Bridge. I will be your moderator today. And I'm delighted to be joined by our host, Richard Farrow, the CEO of APM International, and our presenter, David Clark, who's the Chief Technology Officer from the Trust Bridge. We'll be sharing our insights today on data breaches and how to reduce the risk. Before we start, Richard, could I ask you to give us a bit of background on GCT training?
Hi, thanks very much, Penny. Good afternoon, everyone. GCT training is really about trying to assess the quality of training courses in cybersecurity. There's so many training courses these days in cybersecurity that it can be very difficult for customers to identify those that are good, those that are not very good, and those that are truly appalling. GCT starts to address this issue by providing customers with a choice of rigorously assessed training providers that they feel confident that they will receive training that is consistent with industry best practice. APMG was appointed by the National Cyber Security Centre in the UK, who are part of GCHQ, to provide an independent check as a certification body to assess cybersecurity training courses. And due to our track record in accrediting quality training courses, we've had a lot of success in that and a lot of support. I think to date there's about 100 training courses that are now accredited under the GCT badge. And clearly, data breaches and how to manage them by the Trust Bridge is one of those courses. And I'm delighted to host you today for David to give us some more background on that.
Great, thank you very much, Richard. In today's session, we're going to address some fundamentals on how to manage data breaches, and we'll share, I think with Richard as well, thoughts from a C-suite perspective. So please feel free to ask questions, Richard, as we go through. Before we get into the detail, just to let you know that this webinar will be recorded and available post the session today. And we would like you to ask any questions you like in the chat forum that you will see on your slide. So please ask any questions, and we'll cover those either as we go through or towards the end of the webinar today. So, David, over to you to start talking about data breaches.
Thank you, Penny. So I think one of the things is we're really focusing on how to handle a personal data breach. So you could say this is a subset of managing a potentially, in some cases, a cybersecurity incident. Although I have to say, we've helped companies in the last couple of weeks, and both data incidents have been based on paper, if anyone kind of remembers what that is. We've seen companies that had a file taken by a journalist who thought they could just pick up paper, take it, and it had a huge amount of personal data on, and we managed to work with the company to get that paper back, and an undertaking saying they hadn't looked at it and they weren't going to use that in any inappropriate way. So it does cover absolutely everything. Under the GDPR, there is a definition of what a data breach involves, and that can be disclosure, it can be access, it can be alteration, it can be loss, it can be destruction. And there's another area which we may go to a bit later, is availability can effectively be regarded as a data breach, because if the data subject's rights are affected, actually the availability could be the problem. Maybe 10, 15 years ago, availability was really a relationship to money. You know, how many data centers have you got? What's the availability of those data centers? But now with cloud really means that availability is fairly ubiquitous everywhere, and it probably shouldn't really be a variable we need to worry about. But I think one of the other interesting things is that it brings normal IT into the equation of a data breach, rather than just maybe the cyber guys or the data protection personnel. Because if a system is not available, I think was it last year, and I won't mention the names of the companies, where people couldn't get money out the bank ATM machines, it was causing people problems. I mean, I heard personally of people who couldn't get money out the till, they couldn't pay their petrol bills. So actually it has caused them, you know, distress, harm, and effectively their rights. You know, if you're traveling and you can't get home, it's a major problem.
So that sort of thing, David, is considered a breach. So recognising the type of breach is obviously critical.
Oh, absolutely. And, breaches can be by accident and they could be, malicious. And I think we kind of see a fair amount of that. And unfortunately, what ones that are done accidentally, they obviously cause, distress to the personnel who may have, I think we've all seen them and maybe even done it, sent the right information to the wrong person. And that's probably one of the biggest types of breach that we see listed on the Information Commissioner's website. We don't often really see topping the thing as a guy in a hood, although that is fairly prevalent. Quite often those type of attacks, we may not even realize they've happened for a long time. The ones that are initiated or either maliciously or directly by people are the ones that we find rise to the surface quickly.
You're going to cover this, I know, later on, but once we've recognised a breach, obviously there's a differentiation between those that are notified and those that are reported.
Oh, absolutely. Really, there's two types of breaches. Ones that need to be notified to the Data Protection Authority. They are generally the ones where, especially within the 72 hours, you may not have all the information, but if you have an indication that could have affected the rights and freedoms of the data subject, they need to be notified, in which case, obviously, one of the next stages is you need to inform the data subject. And there's ones that are recordable. And the recordable ones, which basically says it was a breach, but it didn't affect the rights and freedoms of the data subject. And it's important to have those documented, because going through the WP29 now, the European Board of Data Protection, it potentially puts that company in the fining arena for not having the right technical and organizational measures in place. So even if it's a trivial breach and it doesn't amount to much, it's still critical that it's documented.
I think in that case, we should really recap what the key elements are in GDPR that actually will affect anything to do with data breaches. So obviously it came into effect just over a year ago now, in May 2018, and it was designed to harmonise all those privacy laws across Europe. Obviously what we're finding now is that other countries are taking GDPR as a template. So we're seeing things like California, Canada, Singapore,
Absolutely.
Thailand, Brazil, also looking at GDPR. So perhaps, David, you could tell us a little bit more about some of the key elements in GDPR.
Yeah, I mean, I think everybody by now is probably aware that there are potentially huge fines. And the higher fines are generally for data breach, but the lower fines, the 2%, are administrative fines for maybe not complying with some of the documentation aspects, and they can be linked together, and sometimes they're really difficult to separate. And when we look through the enforcement notices that have come out, quite often the fine is not for the breach, it's actually for the organizational measures that have been in place. We've seen companies, I think beginning of last year, that were fined under the old Data Protection Act, and they were actually fined for inappropriate, I guess, what word to say, behavior of managing security and data. So, I think the company in question had encrypted the data. So yeah, that's a great thing to have done. Good idea. But actually the password for the encryption was just kept in a text file. So it negated the whole purpose. And I think the other question they failed to answer properly, I think they'd actually said they didn't realize they had personal data on that server and that it was still in existence. So, it says to, the ICO, actually, you have no idea where your data is until you're not managing your security properly.
And of course, board directors are personally liable. I think there's been the first custodial sentence fairly recently.
Yeah, especially on the surrounding legislation, because it's not all about GDPR. GDPR is the basis, but there is surrounding legislation that's been around a long time. The Privacy Electronic Communication Regulation, sending of texts and emails, and it was amended at the end of last year to allow for custodial sentences. Unfortunately, it tends to be aimed at marketing directors because they potentially the guys who have initiated, a billion SMSs and emails.
Although the board directors are personally liable, one of the key elements is that all employees that have anything to do with data should be aware of how their jobs are affected. So one of the reasons why we've put some training together with APMG is to ensure that people can train all all of their staff, anybody who has any relationship with any customer or any data.
Yes, absolutely. Yeah. And if you go through the breach notification form, and you still can download the Word version from the ICO, I think one of the first or second questions is, have the staff had data protection awareness training? And that potentially leads on, have staff been trained to handle a breach? So they're very strong on, have you done a needs analysis for training across the company? Because obviously somebody who's just filing paperwork will not necessarily be handling a breach, and you may need different training at different levels.
David, picking up on that training for the individual,
yeah.
If you have an employee who has legitimate right to personal data, but then they steal it,
yeah.
and they have been trained, how would the legislation, how would the regulators view that? Because there's very little the organisation could have done to prevent that.
I think we're kind of moving into the Morrison's case of vicarious liability. That was a really interesting one, where a rogue employee, he was allowed access to all the data. I think it was 100,000 employees. And effectively, I mean, he went to prison for it. But what he was doing with the data, he was selling it on the dark net. I'm abbreviating exactly the details here. And what the case Morrison's is now fighting, and it's still got to go to the Supreme Court now, is that the company is responsible for the behaviour of the employee no matter what, even if it is illegal. I think one of the things to probably come out there with our cyber and security hats on is having somebody with that level of access to all that data in one go doesn't seem quite right. In highly regulated environments, you would have a full audit trail. You would have 4 eyes, e.g. 2 people need to approve access. If you're going to extract data, you would need multiple approvals to do that. Obviously, that wasn't there. Maybe they thought that wasn't necessary at that time, but I think it's becoming more and more necessary. There's a recent case with it last week in Canada. I think it was barely 3 million IDs. Same situation, the employee was allowed access. In fact, it looks like he talked his co-workers into giving him extra access or access to their accounts. And of course, you know, unless that's monitored, it's difficult to do. And probably much of that comes down to, if we're still using passwords, passwords can be shared, even if we say no. I mean, I have this problem at home. I kind of run a really tough regime on my children on the internet. And I have this great system where everyone has their own ID and password. Only my son, he kind of figured out pretty quickly. If he borrows mummy's password and ID, he gets access to everything. So, you know, it doesn't quite work so well at home when I tell my wife and my son, this is going to affect your performance management, yeah, and you need to think seriously about, you know, your future. It doesn't work. So it's getting this balance right.
But of course, it's not just inside an organisation, it's also where the data goes. So what's known as the data ecosystem, with third parties, even fourth parties, who get involved in handling the data.
Absolutely, and a lot of our clients, you know, when we've gone in to help them with data protection and cyber, you know, one of the first things is, well, we don't really handle a lot of personal information, and you go, but you do this kind of stuff. Yeah, we don't do it. Our third party outsourcer does it. And of course, what it means is, if your third party makes a mistake, inverted commas, it's still your problem. And you know, we have seen this many times, and unfortunately we've seen them, you know, we've asked the company what went wrong, and they've brought us out every certification under the sun that they've got and all the training. And then we said, okay, that's kind of fine. So it's obviously an accident. Can you do a risk review for us? And of course, the risk review comes back as one line saying, we don't think there's much of a risk. And we go, well, that's nice, but actually, could you tell us what risks you looked at? You know, we're not looking at risks of the company here. I guess with our standard cyber hats, we tend to look at the risks of the company, image, reputation. Yeah, they're all valid risks, but in the data protection world, we are looking at risk to the data subject. What problems will it cause them in the future? Will it cause them embarrassment? Will it cause them potential loss of earnings? Will it cost them, et cetera, you know, relationships?
Well, that leads us into another area that we've had many discussions with clients about, which is what actually is personal information. What is personal data?
Yeah, and I think under GDPR, that obviously the scope has been widened to anything that could eventually identify a living person. And obviously it varies. You know, one of the examples we often give is, if my name is on a piece of paper and you find it in the street, well, I think there's about 30 million David Clarks in England, so it's probably not a big deal. But if I have a very unusual name, and I think I looked this up once, I think Chips is a very unusual, you think it's a common name, but it's actually a very unusual name, it can have a different meaning. So data is very contextual, which is why it's sometimes difficult to get the message across. It's not binary.
So we quite often have clients who say, well, I only have name, Christian name, surname, and email address, so that's not really personal data, and it's a business email address.
It's still regarded as personal data, although admittedly it does depend on the context on how it's used. One of the big questions we always get asked is, what's the scope of GDPR, in and out of Europe? And the WP29 give an example of a company in Monaco, because I think Monaco is not in the EU, but it employs French and Italian employees, and it has their data because they obviously have to pay them, etc. And so the question is, are they in scope? And the actual answer is they're not in scope of GDPR because they're not offering goods and services to the EU. So there are a lot of subtleties there. And we see the same there in the Californian Consumer Privacy Act, that it's very much focused on sales. The CCPA doesn't cover the staff working for those companies. It just covers potentially their customers meeting certain criteria.
But David, if you look at that as personal data, surely if I've got my name, my title, my telephone number, and my web address, my email address, or my business card, and I give that to someone, why is that any different to someone, me trying to protect that? What is the real by giving you my business card, am I legitimately sharing my personal data with you and you can use that? Or is the law grey on that area?
That's a really good question. And a lot of it comes down to the concept of the right of expectation, which actually came from the US in the 60s. It is, if I give my data to somebody, what is my expectation of how that data will be used? And if I'm giving you my business card, is my expectation that you will ring me about something? And I think my expectation would be, otherwise I wouldn't have given that business card. And we saw this, I think, was it last year or the year before, where Jeremy Corbyn had his photo taken in the Virgin train sitting on the floor. And he was saying the trains were overcrowded. So that hit the front pages of the national newspapers. And Virgin responded with their CCTV camera photos, which showed the carriage empty other than 3 people, and I think Jeremy Corbyn sitting on the floor. They got questioned then by the ICO saying, this is a little bit unfair on those 3 people because their expectation of CCTV is that it's there to protect them, not to put their pictures on the front of a national newspaper. So same data, same photo, totally different connotations.
Thank you.
So that perfectly leads into what constitutes a personal data breach.
Well, we've got the criteria of loss, alteration, disclosure, access, and one of the examples on the ICO website, and I've got to make sure I get the maths right on this, is that a hospital worker looks at the wrong patient's data, and they regard that as a potential disclosure breach. So, but when you look at the way this works, you may have 10,000 patients, 200 systems, and 50 staff. Multiply those together, and you're kind of in the region of 100 billion data points. So a 1% error in managing the privilege and access control is 1 million data points. So this then comes to the question, is data protection a technology-driven issue, or is it a user training? And I tend to think it's both, because I think, maybe 30 years ago when we had paper files, it was a lot easier to do than having the huge volumes of data now that we have to take care of.
Yeah, that's true. Although we have a recent client came to us with some crisis management on a notebook that had been left on a train by an employee with quite a lot of pretty sensitive information. It was actually a charity.
Yeah.
So that clearly is not a technology loss so much as a manual error.
Potentially, yeah, absolutely. And we've seen that quite a lot recently, where paperwork has gone missing or left in the park.
Is there a period of time, David, between losing data and it being used maliciously? So if you take the notebook loss, if the notebook had been picked up by the cleaner, put in the bin,
Yeah.
and actually thrown away, it is a loss, but there is no damage done. Or it could have been picked up by the cleaner and left somewhere,
somebody else,
and then a rogue finds it later on and then misuses it maybe 2-3 months later.
No, absolutely, and I think that's often the difficulty. We kind of might know that stuff has been destroyed, but are we really sure it's been destroyed? A bit like the ransomware. The ransomware concept is encrypt it, pay us, and then we'll release it. But how do we know a copy hasn't been made? Sometimes it's very difficult to ascertain. So actually, we've got to take the risk that there was a disclosure. How do we manage the disclosure is really what we're asking. And that is helping that data subject, monitor his accounts, monitor any inadvertent effects, and helping them when they need it.
Yeah, I think I'm in the John Paul Getty world when it comes to paying ransom. You don't.
Yeah, I think that's kind of a question that has to be sort of dealt behind with closed doors, because sometimes it just might be necessary, but this is not a recommendation on any of this. Much of this could have been prevented, and many cases prevention is way easier than the cure, because we've seen stuff where actually you paid the ransom and the unencryption didn't work anyway, so you're no better off.
So surely that should be in your data breach policy.
Well, it comes under the destruction thing. What we're saying here is, the thing is, we know bad things will happen. It's how you manage bad things. It's the things that keep you out of trouble. And from the Canadian one last week, I think the legislatures there are already saying this was handled really well. We're happy the way the bad thing was handled, although it was a bad thing.
Talking of bad things happening and liability, what's the liability of the data privacy officer?
Yeah, the guidance on that basically says they're there for advisory. So they have a protected role. So it's very difficult, I think, to sort of say that you didn't take their advice, because most data protection officers, data privacy officers, will advise to the highest level. And if that's not done, there's a risk there that's got to be taken by the company. Where there's a great unknown is the role of the representative. And that means that, say, for example, a company in the US is selling goods and services to Europe. They need a person in the EU who effectively will give all the guidance and potentially take some of the liability. And I think there's a case in Denmark at the moment where they're picking on the representative and the US company at the moment, and we've yet to see the outcome. So the representative looks like a potentially high risk role where anything goes wrong for that company, that poor representative is potentially in the firing line. But we've yet to see that enacted, but that's what it's looking like at the moment.
So the key thing, David, I think, is recognising a breach has occurred, and then we can start to look at what you need to do once you recognise that. So how do you go about recognising that a security incident has taken place both with you and or with a third party?
That's a good question. Thanks, Penny. GDPR, and I'm paraphrasing Elizabeth Denham, the Information Commission Officer, she's basically sort of said GDPR is about two things: delivering the rights and managing breach. And probably for most companies, if you're starting from now, managing breach is probably one of the quickest and easiest things to get up to speed on. But it does require one thing: it requires the company to know that they are potentially having a breach. And many companies that we've worked with, we've gone to their legal department and say, how do you guys manage breach? And they go, we don't. It's the security department. We go to the security department and we go, hey, how do you guys manage breach? And they go, it's the legal department. So it doesn't take long to figure out that actually nobody manages breach. And if there's no way of reporting it, you don't get them, which is great if you're in the plausible deniability area, which I think these days is not really holding them much water anymore, because companies should have this stuff in place. There's always a worry that, if you make it too easy, you'll get overloaded. But in some of the big entities I work for, yeah, it just hasn't happened. People are very sensible. And I personally would rather, when I've been responsible for it, would rather have a heads up that this might be something and contain it early, rather than let's ignore it till, the CEO or the press get it. It's much better to be advanced.
So really, notifying is something that you would recommend we do regardless.
Well, I think knowing about it internally first, then putting it through the risk analysis, and we cover that in the course. You know, what are the risks, and if the risks look bad, the way you can do it, you can weight the risks and you can decide, you know what, this looks like this is a potential, let's do the notification. Bearing in mind, the ICO have said that they will use breach notification as a litmus test for how the company is handling data. So you've got to be prepared, whatever goes in there also demonstrates the capability of the company. And as we said earlier, the one thing that everyone can do early is training. And I mean, I wouldn't like to be in a position where I had to fill out the form and saying we've just started the training of the staff, because that probably doesn't look too good. So
I mean, that's another interesting point, David. We were ready for GDPR when it came in.
Yeah.
So it took us about 15 months, I think, to prepare for it, because we got rid of quite a lot of documents, duplication. We found we were holding personal identification in various places, and we trained everybody.
Yeah.
So what would be the penalty now if there was a breach and you hadn't done anything of that and it was still work in progress?
I think it's difficult to know how the penalty would go, but what we've seen in the enforcement notice is if companies seem to be playing kind of fast and loose with stuff, they do receive a higher penalty. I think what we saw in the Emma's Diary one, for example, where they had sold data of mums and pregnant mums data, is actually to a third party who I think is still under investigation. And that was then sold to a political party for political aims. What happened when you read through the enforcement notice, during their investigation period, it looked like they may not have been as forward as maybe they should have been. And during that period, they altered their privacy notice, just 2 words. They added the words political use on there. And this was noticed by the ICO. And because they said, well, actually, you knew that you needed to put those 2 words in there, political use, I think they received a 170k fine. Whereas maybe if they'd been more cooperative, I think is the word, that may not have happened.
Right, thank you.
And I think some of the other fines have been to do with the delay in actually reporting or notifying. So there are some quite strict timings involved, aren't there?
Yeah, it's the 72 hours. And of course, we always kind of, I don't say we kind of like, but we always keep our ears and eyes open on the bank holiday weekend, where you have bank holiday Friday and bank holiday Monday, because the Thursday night is prime time for maybe kind of cyber and breaches, because if you get one on Thursday, you've only got 72 hours. So Thursday, Friday, Saturday, nobody's at work, nobody's on call, no process in place. You've got a tough time between Sunday, Monday and Tuesday, first thing in the morning.
What about telling the data subject? Is that required in every case?
If there is a risk to the rights and freedoms, obviously, and it's how you tell them, because you may need to make sure that your data hasn't been altered, that you're actually telling the right person, and managing that correctly. If it is very difficult, you may need to do a different way, broadcast it on the radio or the internet if the scale is too huge. But also be prepared. How are you going to offer mitigation? How are you going to present it? And also there may be stuff ongoing at that time, and if you broadcast it, they may cause even more detriment to the data subject. So a lot of this has to be taken in and balanced out.
So that description of any consequences of the breach should be notified to the data subject?
Ideally, yeah, ideally, absolutely.
And a description of the measures that the organisation
put in place. I mean, the CCPA, the Californian one, they actually give the companies 30 days to rectify it, which is, how do you rectify a breach when it's gone too far already? Interesting question, though we're going to see pan out next year.
Yeah, so some of the risk factors that we need to consider when we're looking at all of this is the type of breach and its sensitivity and volume of the personal data, how easy it might be to identify the individuals and those consequences. But I think the really key thing for me here is the special characteristics, such as children and vulnerable adults. And there are special laws and regulations around
absolutely, and the GDPR is quite kind of robust on this, that the controls and access and management of this has got to be much tighter, because obviously.
But David, isn't that very subjective? Certainly the severity of consequences for individuals that must be very variable depending on the personal circumstances. So in your breach early, you know, the 3 million nearly names that went, if you went through that, the consequences for individuals could vary greatly.
Absolutely. And, you know, what we try and do, and, you know, there's plenty of information on the ICO website as well and around the world, is looking through potential risks to the data subject and then doing an evaluation on it. So you're quite right. I mean, it is often very difficult, and some of the things on smaller breaches that we've worked on, where there, for example, there was high net worth individuals, what does that mean to them? High net individuals are generally a target for everybody because they are high net worth individuals, and that risks how it's going to be mitigated may be different in every circumstances. Some of them may be used to it and they kind of expect that they are a target. Others may be very, very vulnerable. You know, the consequences can be different.
Thank you. And I have a technical question for you, because I've read a lot about some of the requirements, and within APMG, we often get people asking to be forgotten, to remove their name from a database or whatever. And we've also been looking at the concept of blockchain and distributed ledgers.
Yeah.
Now, my understanding is that in a distributed ledger, you can't change a record. So once your personal data is in a distributed ledger, it's there. So is anyone thinking of this clash between legislation, my right to be forgotten, and technology innovation, the ability not to change a record? Where does it sit in terms of GDPR?
Absolutely. And I think actually this is where it gets interesting. It's actually a right of erasure and the right to be forgotten. They're said in the same line. And the right to be forgotten originated from Google and a case where a guy wanted to be forgotten in Spain. And really what that meant was unlinking him from the search engine. It didn't mean deleting his data. So his data still existed on various websites, but you couldn't find it in the Google search engine. Although now his name is everywhere because of his name in the case. But and the right of erasure is a real tough one. I mean, we've seen, you know, with the good use of cloud systems, backup systems, very, very sophisticated, backing out every 15 minutes. 15 minutes over 2 years potentially means every record's backed up 30,000 times. So how do you go through the backup? Is it possible, or do you have to kind of do the next best thing, is actually prevent the restoration of it? So deletion in itself, what actually does that mean? It doesn't say in the GDPR you must delete to a military standard. So is it kind of inferring that the next best thing would be some kind of masking so it can be done? Quite often, the next level of difficulty before that is the right of restriction, because quite often if somebody rings up and says, I want to be deleted, ideally the first thing you would do is put them on restriction and then investigate whether it's even legally possible to delete them, maybe tax, health, pension, huge raft of things that they may need to still keep their name and some of their details there. So it then comes down to, I guess, sophisticated data management, and I think the world's not quite ready for that in many cases. We've all got legacy systems. I think once a company gets more than 6 months old, they've already got legacy data, let alone companies who have been going 20 years where they will have hundreds and hundreds of systems with legacy data. And how do you restrict, how do you mask it, how do you delete it?
Yeah, I was talking to someone in the construction industry and they said they have personnel records going back 70 years.
But is that because they might have, breathed in asbestos? Where
they were concerned about asbestos, so they've now deleted them.
Really?
Under GDPR. It's better to run that risk and pay out a claim that may not be valid than it is to run the risk of a breach.
It's true, very true. But remember, GDPR, in the laws are kind of a hierarchy, and often GDPR is the lowest. Financial, health and safety will take priority. We've been asked a great question when we were doing work for some call centres, and they were dealing with some very sensitive people ringing in. And one day we got a call saying, can we share this data with the police? And I said, well, what's the question? Well, I think the guy, I'm probably overemphasizing it, but he was going to cause serious damage to his family, neighbors, and the rest of the world. And, the answer is, of course, this is vital interest where lives are at stake. It supersedes data protection and of course give that data to the police.
Well, it doesn't seem to be the other way around though, does it? At times the police or law enforcement will say, I can't give you to that under GDPR.
Well, they get hit all the time, don't they? And we saw was it the Home Office a few weeks ago had to delete those voice recordings. I think it was barely 5 or 6 million of them.
But that's one of the things that we've talked to clients about right at the beginning of any contact with them, is that they should really understand what data they've got and where that data is. One client, for example, had all resumes that had been sent to them for job applications going back 20 odd years, just in case. Well, clearly the resume was going to be out of date, there may be a different job, so why keep that data? Get rid of the data, there's no need for it. So just looking at what data you're holding and why you're holding it is probably the first step. I mean, there are other steps, just looking at the slide we've got here, really to try and mitigate the risk of a data breach and actually respond to a data breach. There are a number of things that the client should be doing, or a company and organisation should be doing. Obviously, learning from a breach, so taking remedial action and then documenting what's been done and what you're going to do in future.
And that is one of the most important things, because I guess with cyber hat on, we're always kind of worried about access breaches, but actually, you know, disclosure, destruction are equally as important.
And undertaking additional training. So once something's happened, clearly go back over it with all the staff to make sure they understand
the lessons learned, all that. And many people who are in the cyber field will be very familiar with that. It's a very similar process under the ISO 27001.
Sure. How
you manage an incident, what you need to do, what the criteria are.
David, on the penalty side, I know penalty looks quite large at sort of 4% or 20 million, but some people might see that just as a business risk.
And I think you're right. I'm not sure that many companies are overly worried about fines. I mean, I think on the way here this morning, I heard of one of the banks has fined 45 million for some kind of money laundering event. Not a big deal. Some of the big banks get fined 300 million. It's a cost of doing business. Well, where I think it is probably more concerning is if there's any personal liability, and some of the areas do have some personal liability and potentially custodial sentences. And that's the bit that would probably worry me more.
And that probably would worry the banker as well.
Absolutely.
But do you think there could be an escalation so that if you've had 3 breaches, say in 2 years, someone decides you're not treating this legislation correctly, and there could be another penalty brought in? Well, you might be out of business because your clients have probably lost trust in you with 3 breaches in, say, 2 years.
I think there's a number of things. I think the very first GDPR enforcement was done in July to a Canadian company to cease and desist. And if you're not allowed to do that data processing, you have no business. So that would be the number one fear. And I think secondary, the other thing that we saw fairly early on after the GDPR was in the US, a GDPR class action. So, the consequences could be a real force multiplier that, you can't do the data processing, you may have class actions going on, and you may get fined. We haven't seen all of that yet, but, that is coming. But on the kind of positive side, I think we are seeing technology now evolve and help us much more with data protection, because I think the reality is most of our systems are not designed for data protection. When we get in an aeroplane, we know it's safe. When we get in a car now, we know it's safe. We know food is safe. The one thing we know about IT and infrastructure, it's probably unsafe. In fact, it's almost a guaranteed event. And that's because we've designed stuff to deliver phenomenal, output and results, but it's not with data protection in mind, and we can see that changing now.
I think you might be a little harsh to some of our colleagues to say it's probably guaranteed that IT systems are maybe unsafe, but I did take your point. Thank you.
I think there's probably a data breach happening pretty much everywhere of one degree or another,
well,
pretty much every day.
This famous saying, wasn't there, by the ex-FBI, head of the FBI, I think his saying was, there are 2 types of company, ones that know they've been breached and the ones that don't.
Yeah.
Thank you, David. Thank you, Richard. That was very interesting. As you can see on the screen now, we have a number of training schemes available through our portal, one of which is with APMG GCHQ on data breaches and how to manage them. David told me this morning that as it's his birthday next week, he's very happy to let everybody who's been attending this webinar today to have a discount on that, of course, if they'd like to go to the portal and enroll for that. So we will be emailing out the special discount code to everybody who attended the webinar today. There are a couple of questions here. One is from Estelle. She's asking us, are there any quick fixes, especially in the marketing area, to make sure that you're not breaching?
I think from a breach perspective, yeah, there's kind of always three main things. Make sure you can demonstrate training, record all the breaches and do the risk analysis. I think if those three are covered, you know, you're probably in a much better place than most other companies.
Another question here is on the timing. You say there's 72 hours. What happens if you don't find out within that 72 hour period?
I think the wording is once you become aware.
So as soon as I become aware of a breach, it might be 2 or 3 weeks after the breach has actually happened.
Absolutely, and often, you know, some of the more complex breaches we've been involved with, you actually don't know what's gone on, which is the real problem. You know something's gone on, but you can't quantify it, and you're still figuring it out. And if you think that's risk, that's really what the trigger.
Are there any cases where you can give us some idea of where that might have happened?
I think the average reporting of a breach of discoverable is over 200 days on average. Gosh. So I think that's sort of common throughout the industry, every industry.
So if the breach has happened with a third party and I don't find out about it, when does until several weeks later, when does the time start?
The GDPR actually says in the contracts there should be proper data processing arrangements between the entities. And I think the guidance is as soon as possible, report the breach to the controller so they can handle it. What we've seen a lot is that I guess it's a bit overrun with legalese. Some of them say within 24 hours or 48 hours, but ideally you need every minute to evaluate that. So I would definitely recommend, and from past experience, because remember, data breach wasn't invented by the GDPR. It's been going on decades and decades. And we always kind of said, if you think you've had a problem, let us know, because a heads up is way better than waiting until you know everything perfectly.
We have a question here from Chris Roberts. How are your clients reacting to Brexit, risk and breaches across borders? Well done, Chris. We've managed to get through 45 minutes without mentioning Brexit.
What is this Brexit? Yeah, I think what we're kind of seeing now that probably if let's take an easy scenario. It's a company in the US that has a presence in the UK and Europe. They will probably have to report that to at least 2 data protection authorities and have potentially 2 representatives if they don't have entities locally. So it's going to be the same process, but maybe multiplied by at least 2.
That is actually a whole other subject, the subject of the nominative representative office, which obviously will affect companies post-Brexit.
Because the concept, one of the concepts was the one-stop shop in the GDPR, where if you had a problem, you reported it to one data protection authority, and it was sort of sorted. And now it's going to have to be at least 1 + 1, potentially at the moment.
Or they don't work in the UK, but if you're in Europe working in multiple European countries, within the EU, I assume you just need 1 representative.
Potentially, yeah. Yeah. Well, we haven't seen this tested. This is kind of interpretation at the moment. Yeah.
Kishore has asked, how do we determine an intentional and an accidental breach? That's a tricky question.
You may not be able to initially. Quite often, many breaches are accidental. That's for sure. Intentional, that probably needs a lot more work and investigation.
And presumably you would report your thoughts on that to the ICO when you're notifying them and reporting.
Absolutely, and generally we recommend kind of keeping names out of this. The number of breaches we've seen where people have said it's Fred Bloggs, and poor Fred Bloggs was in a million emails internally, loads of documents. Guess what? He was on holiday that week and it wasn't him anyway. So it's very, very careful about naming names, especially in internal documentation.
Great, that's all the questions we have today. Thank you very much, Richard, for hosting us here today, and thank you, David. Any other questions, please email them to us. Our contact details are on the slide that you can see on your screen, and we'd be delighted to hear from you.
Thank you, Penny and David. I think on behalf of everyone that joined the webinar, it's very interesting 45 minutes. I'm not sure that I am any happier about GDPR than I was 45 minutes ago, but I'm probably more informed. So thank you very much. Thank you both very much for putting on the webinar for us all. Thank you.
Thanks, Richard.
Thanks, Richard.